Question 1. During a major transformation where existing methods are being challenged, a state legislature enacts a law that significantly limits the ability of a regulatory agency to issue fines against businesses for non-compliance with environmental regulations. The agency, which previously had broad discretionary power under federal law, argues that this state law conflicts with federal environmental statutes. Which of the following principles will most likely determine whether the state law is valid? A. The supremacy clause of the U.S. Constitution. B. The 10th Amendment protecting state sovereignty. C. The non-delegation doctrine limiting agency authority. D. The major questions doctrine restricting regulatory expansion. Answer: A. The supremacy clause of the U.S. Constitution. Explanation: the supremacy clause, Article Clause 2 of the U.S. Constitution, establishes that federal law takes precedence over state laws when there is a conflict. Here, the state law restricting fines conflicts with federal environmental regulations, which derive from acts such as the Clean Air Act, CAR, and Clean Water Act, both of which grant federal agencies, e.g., the Environmental Protection Agency, the authority to enforce compliance. Courts typically follow the doctrine of preemption, which applies when express preemption. Congress explicitly states that federal law overrides state law. Implied preemption. The state law interferes with federal objectives or makes compliance with both state and federal law impossible. In this case, implied conflict preemption arises because the state law undermines federal environmental protections by limiting enforcement. This was seen in California v. United States, 1978, where state regulations were found unenforceable because they directly conflicted with federal statutory objectives. Other options: B. The 10th Amendment. While it reserves powers not delegated to the federal government to the states, it does not override federal supremacy when federal and state laws conflict. C. The non-delegation doctrine. This doctrine restricts Congress from delegating excessive legislative power to agencies, but does not apply to conflicts between federal and state law. D. The major questions doctrine. This doctrine applies when aid interprets statutes in ways that make sweeping regulatory changes, not when there is a federal-state law conflict. Question 2. In an environment where different components must interact under evolving laws, a federal agency adopts a new data privacy regulation requiring companies to obtain explicit consumer consent before collecting personal data. A trade association files a lawsuit arguing that the agency exceeded its statutory authority because Congress had not clearly delegated such power. Which judicial principle is most relevant? Determining whether the agency's rule is valid. A. The Chevron deference doctrine. B. The Dormant Commerce Clause. C. The Void for Vagueness Doctrine. D. The Equal Protection Clause. Answer: A. The Chevron Deference Doctrine. Explanation: under Chevron U.S. Inc. v. Natural Resources, Defense Counsel, 1984, courts apply a two-step test to determine whether a regulatory agency's interpretation of statute is lawful. Has Congress spoken clearly on the issue? If the statute is clear, the agency must follow Congress's directive. If the statute is ambiguous, is the agency's interpretation reasonable? If so, courts generally defer to the agency's expertise. Here, if the statute governing data privacy does not explicitly mandate obtaining explicit consumer consent but allows for broad regulatory authority, courts may defer to the agency's interpretation unless it is deemed arbitrary and capricious under the Administrative Procedure Act. Other options: B. The Dormant Commerce Clause. This prevents states from enacting laws that unduly burden interstate commerce but does not apply to federal regulatory agencies. C. The Void for Vagueness Doctrine. This applies to laws that are so vague they fail to provide adequate notice of what is prohibited, primarily in criminal or First Amendment contexts. D. The Equal Protection Clause. This prevents the government from treating individual groups unfairly but is not directly applicable to agency rulemaking. This issue is similar to FCC v. Fox television stations, 2009, where the Supreme Court emphasized the importance of clarity in regulatory enforcement. Question 3. While investigating inconsistencies across various units, a company is found to have misclassified employees as independent contractors to avoid compliance with federal wage and hour laws. The Department of Labor, DOL, initiates enforcement actions under the Fair Labor Standards Act (FLSA). The company argues that it followed state law definitions for classification. Which legal principle determines whether federal labor law over state definitions in this case? A. The economic realities test. B. The police power doctrine. C. The takings clause. D. The lenity doctrine. Answer A. The economic realities test. Explanation: the economic realities test, established in United States v. Silk, 1947, and applied by the DOL, evaluates whether a worker is an independent contractor or an employee based on multiple factors such as degree of control exercised by the employer, worker's opportunity for profit or loss based on initiative, investment in equipment or materials, permanency, relationship, skill level required for the job. Under the Fair Labor Standards Act (FLSA), federal law generally preempts conflicting state labor definitions, especially when it comes to worker protections. This was reinforced in Rutherford Food Court v. McComb, 1947, where the Supreme Court ruled that economic dependency on an employer signifies an employment relationship under federal law. Other options: B. The police power doctrine. States have broad powers to regulate for public health and safety, but these powers do not override clear federal wage and hour protections. C. The takings clause. This applies to government seizures of private property, not employment classification disputes. D. The lenity doctrine. This applies to criminal statutes requiring ambiguity to be resolved in favor of defendants, not regulatory labor. The case of Dynamics Operations West Inc. v. Superior Court of Los Angeles, 2018, illustrates how courts distinguish between state and federal tests, with the ABC test being used in some states but not overriding federal FLSA standards. Question 4. Topic: Constitutional and administrative law. During a comprehensive review of a process that needs improvement, a federal agency, under its delegated authority, implements a new rule that significantly restricts certain business operations. The rule, however, has widespread economic implications, leading several business groups to challenge its validity in court. The businesses argue that the rule exceeds the agency's authority, imposes unconstitutional restrictions on commerce. The agency counters that Congress has granted it broad discretion to regulate in the public interest. Considering the principles of constitutional delegation of powers and administrative rulemaking, which of the following factors would most likely determine whether the agency's rule is valid? A. Whether the agency's interpretation of its governing statute is reasonable under the Chevron deference doctrine. B. Whether the rule was passed with unanimous approval by all commissioners in the agency. C. Whether the rule was explicitly approved by the President through an executive order. D. Whether businesses can demonstrate economic harm, regardless of whether the agency had statutory. Answer A. Whether the agency's interpretation of its governing statute is reasonable under the Chevron deference doctrine. Explanation: the validity of the agency's rule hinges on whether the agency's interpretation of its governing statute is reasonable under the Chevron deference doctrine, established in Chevron U.S. Inc. v. Natural Resources Defense Council Inc. 1984. This legal principle holds that courts should defer to an agency's reasonable interpretation of an ambiguous statute, provided that Congress has delegated authority to the agency. A. Correct. Under Chevron deference, courts will uphold an agency's regulation if 1. Congress has not clearly addressed the issue in the statute, and 2. The agency's interpretation is reasonable. B. Incorrect. Unanimous approval by commissioners is not legal requirement for rules validity. Agency decisions often involve dissenting opinions. C. Incorrect. Executive approval is not required for rulemaking unless the rule is subject to direct executive oversight under statute like the Congressional Review Act. D. Incorrect. Economic harm alone does not invalidate rule unless the agency has exceeded its statutory authority or violated due process. Question 5. Topic: Employment and labor laws. While investigating inconsistencies across various units, a multinational corporation discovers that its compliance policies regarding wage and hour laws vary significantly by state. The company operates in multiple jurisdictions, including states with stricter minimum wage laws than the Federal Fair Labor Standards Act (FLSA) requirements. However, some managers have been incorrectly applied federal standards instead of state laws, leading to underpayment of employees. Which of the following is the best legal approach the company should take to rectify compliance issues? A. Apply the federal FLSA minimum wage and overtime rules uniformly across all locations. B. Apply the highest applicable standard of wage and hour laws, whether federal or state. C. Seek an administrative waiver from the Department of Labor to comply only with federal laws. D. Require employees to sign a waiver agreeing to be paid based on federal law instead of state law. Answer: B. Apply the highest applicable standard of wage and hour laws, whether federal or state. Explanation: the general rule under wage and hour laws is that employers must comply with the most employee-favorable standard, whether it is federal or state law. A. Incorrect. The FLSA establishes minimum wage and hour requirements, but states can impose stricter standards. Employers must adhere to whichever law provides greater protection. B. Correct. If a state law mandates a higher minimum wage or more generous overtime provisions than the FLSA, the employer must apply the stricter standard to employees in that state. C. Incorrect. The Department of Labor does not grant waivers allowing employers disregard stricter state wage laws. D. Incorrect. Employees cannot waive their right to be paid according to applicable wage laws, but such agreements would be unenforceable under public policy considerations. Question 6. Topic: Business and economic regulation. In a high-stakes environment where multiple challenges exist, a group of technology firms is accused of engaging in anti-competitive behavior under federal antitrust laws. The government alleges that these firms have collectively restricted access to key technologies, limiting competition and harming consumers. The companies argue that their practices are necessary to protect their proprietary innovations. Under U.S. antitrust laws, which of the following would be the most relevant legal test to determine whether the firm's actions violate competition laws? A. The per rule, which automatically deems all restrictions on competition unlawful. B. The rule of reason, which evaluates whether the conduct unreasonably restrains trade. C. The essential facilities doctrine, which applies only to physical infrastructure cases. D. The Noah Pennington doctrine, which protects firms that engage in lobbying activities. Answer: B. A rule of reason, which evaluates whether the conduct unreasonably restrains trade. Explanation: the rule of reason established in cases like Standard Oil Company v. United States, 1911, is the primary legal test in antitrust law to assess whether a business practice unreasonably restrains trade. A. Incorrect. The per rule applies only to inherently anti-competitive actions such as price fixing or bid rigging, but does not apply to all competition restrictions. B. Correct. The rule of reason requires courts to examine the actual impact of business practices on market competition before determining their legality. C. Incorrect. The essential facilities doctrine applies in cases where a dominant firm denies competitors access to a necessary infrastructure, e.g., railways, pipelines. D. Incorrect. The Noah Pennington doctrine protects companies from liability when lobbying the government, which is not relevant to private business agreements. Question 7. Topic: Criminal law and regulatory compliance. During an emergency response where multiple areas are impacted, a major pharmaceutical company is investigated under the False Claims Act (FCA) for allegedly misrepresenting the efficacy of a drug in government contracts. The Department of Justice (DOJ) is pursuing both civil and criminal penalties against the company. Which of the following would be the strongest legal defense against liability under the False Claims Act? A. Demonstrating that scientific uncertainty prevented the company from making definitive claims. B. Proving that the misrepresentation was unintentional and due to clerical errors. C. Shown that the government had prior knowledge of the inaccuracies but continued to purchase the drug. D. Establishing that the company voluntarily disclosed the errors before an investigation began. Answer: D. Establishing that the company voluntarily disclosed the errors before an investigation began. Explanation: the False Claims Act 31 U.S.E. SSS 3729-3733 imposes severe penalties for knowingly submitting false claims to the government. However, voluntary disclosure of violations can significantly reduce penalties under the FCA's self-disclosure provisions. A. Incorrect. Scientific uncertainty may affect liability but does not excuse fraudulent claims made with reckless disregard for accuracy. B. Incorrect. The FCA applies to knowingly false claims, but even reckless or deliberately ignorant statements can trigger liability. C. Incorrect. Government knowledge of inaccuracies is weak defense unless the government explicitly approved the claims. D. Correct. Voluntary disclosure before an investigation begins may reduce penalties under Dutch self-disclosure guidelines and corporate compliance programs. Question 8. Topic: Contract law and business transactions. During a detailed assessment of a contract that governs multiple jurisdictions, a company discovers that a supplier has failed to deliver goods as promised due to a supply chain disruption. The contract contains a force majeure clause which excuses non-performance under extraordinary circumstances. However, the buyer argues that the supplier could have taken reasonable steps to mitigate delay and is therefore still liable. In determining whether the force majeure clause applies, which of the following factors would be most relevant? A. Whether the specific event that caused the disruption is listed in the force majeure clause. B. Whether the supplier notified the buyer immediately about the disruption. C. Whether the force majeure clause was negotiated equally by both parties. D. Whether the buyer suffered financial harm due to the delay. Answer A. Whether the specific event that caused the disruption is listed in the force majeure clause. Explanation. A force majeure clause excuses non-performance only if the event is explicitly covered in the contract. Courts typically consider the specific wording of the clause and whether the disruption was unforeseeable and beyond the parties' control. A. Correct. If the event, e.g., natural disaster, government lockdown, is specifically listed, the supplier may be excused. B. Incorrect. While timely notification is important, it does not determine whether force majeure applies. C. Incorrect. The fairness of contract negotiations does not affect the enforceability of properly drafted force majeure clause. D. Incorrect. Financial harm to the buyer is not determining factor unless stated in the contract. Question 9. Topic: Constitutional law and governmental authority. While performing a thorough analysis of a newly enacted statute, a legal team identifies provisions that appear to violate the separation of powers doctrine. The law passed by Congress gives an independent federal agency the unilateral authority to enforce, adjudicate, and impose penalties without judicial review. Which constitutional principle is most likely to be used? Challenge this statute. A. The non-delegation doctrine, which limits Congress from transferring its legislative powers. B. The Dormant Commerce Clause, which restricts state interference with interstate commerce. C. The Privileges and Immunities Clause, which ensures equal treatment across state lines. D. The Takings Clause, which prohibits government seizure of private property without compensation. Answer A. The non-delegation doctrine, which limits Congress from transferring its legislative powers. Explanation. The non-delegation doctrine prevents Congress from granting unchecked powers to agencies without clear guidelines. A. Correct. If the statute grants an agency legislative, executive, and judicial powers without proper oversight, it violates the separation of powers. B. Incorrect. The Dormant Commerce Clause applies to state, not federal, regulations affecting interstate commerce. C. Incorrect. The Privileges and Immunities Clause relates to state discrimination against non-residents, not agency authority. D. Incorrect. The Takings Clause applies property seizures, not delegation of government powers. Question 10. Topic: Securities law and financial regulations. During a critical financial review, an investor uncovers that a company has been artificially inflating stock prices by misrepresenting revenue projections in quarterly reports. The SEC launches an investigation under the Securities Exchange Act of 1934. Which of the following elements must the SEC prove to establish liability under Rule 10.5? A. The company's misstatements were intentional and led to investor losses. B. The company failed to register its securities with the SEC. C. The company engaged in unfair competition, harming competitors. D. The company's executives personally profited from the misrepresentation. Answer A. The company's misstatements were intentional and led to investor losses. Explanation. Under Rule 10.5, securities fraud requires scienter, intent to deceive, and reliance by investors. A. Correct. The SEC must show that the misstatements were material, made with intent, and resulted in investor harm. B. Incorrect. Failure to register securities is separate violation under the Securities Act of 1933. C. Incorrect. Unfair competition laws do not govern securities fraud. D. Incorrect. While personal profit may indicate fraud, it is not required element under Rule 10.5. Question 11. Topic: Corporate law and fiduciary duties. In a high-stakes corporate merger, a board of directors fails to disclose a material risk to shareholders before approving the deal. Later, the company suffers massive losses due to this risk, and shareholders sue the board under fiduciary duty principles. Which duty did the board most likely breach? A. The duty of care, which requires directors to act with diligence. B. The duty of loyalty, which prohibits conflicts of interest. C. The business judgment rule, which protects directors from liability. D. The duty of good faith, which mandates fair dealing. Answer A. The duty of care, which requires directors to act with diligence. Explanation. The duty of care requires directors to make informed decisions and disclose risks. A. Correct. Failing to investigate or disclose risks is a duty of care violation. B. Incorrect. The duty of loyalty applies to conflicts of interest, not disclosure failures. C. Incorrect. The business judgment rule protects directors if they act informedly, which they fail to do. D. Incorrect. Good faith violations involve intentional misconduct, not negligence. Question 12. Topic: Real estate law and zoning regulations. During a long-term development project, a commercial developer seeks to build a high-rise office tower in a neighborhood zoned for residential use. The city denies the permit, citing zoning laws. The developer sues, arguing that the denial constitutes an unconstitutional taking under the Fifth Amendment. Which legal test will the court most likely apply? A. The Penn Central test, balancing economic impact and government purpose. B. The per-takings test, which applies to physical government seizures. C. The Dormant Commerce Clause test, which applies to interstate business. D. The strict scrutiny test, which applies to fundamental rights cases. Answer A. The Penn Central test, balancing economic impact and government purpose. Explanation: in regulatory takings cases, courts apply the Penn Central test to determine if a zoning law goes too far in restricting property use. A. Correct. The Penn Central test considers 1. Economic impact, 2. Interference with expectations, and 3. Government purpose. B. Incorrect. The per-takings test applies only to physical appropriations. C. Incorrect. The Dormant Commerce Clause governs state restrictions on interstate trade, not land use. D. Incorrect. Strict scrutiny applies to constitutional rights, not property regulations. Question 13. Topic: Contract law and breach of agreement. During a thorough contractual review, a company identifies that a supplier has delivered defective goods that do not meet the quality standards specified in the agreement. The buyer refuses to pay and demands a refund. The supplier claims that the buyer accepted the goods by not rejecting them immediately upon delivery. Under the Uniform Commercial Code, which of the following actions would best support the buyer's claim for refund? They had shown that the goods had latent defects that were not immediately detectable. B. Arguing that the contract was signed under duress. C. Demonstrating that similar goods are available at low price elsewhere. D. Providing evidence that the supplier had history of delivering defective products. Answer A. Showing that the goods had latent defects that were not immediately detectable. Explanation: under the UX rules on acceptance and rejection, buyer must reject defective goods within reasonable time after inspection. A. Correct. If defects were not immediately visible, latent defects, the buyer may still reject the goods even after acceptance. B. Incorrect. Duress is contract formation defense, not remedy for defective goods. C. Incorrect. Price comparisons do not affect contract enforceability. D. Incorrect. The supplier's past behavior is not relevant unless the contract included warranty. Question 14. Topic: Employment law and discrimination cases. During a detailed review of workplace policies, an employee discovers that their employer has systematically denied promotions to individuals over the age of 50. The employer justifies the policy by arguing that younger employees have more long-term potential, which federal law provides the strongest legal protection against this practice. A. The Age Discrimination in Employment Act (ADEA). B. The Fair Labor Standards Act (FLSA). C. The Occupational Safety and Health Act (OSHA). D. The Family and Medical Leave Act (FMLA). Answer A. The Age Discrimination in Employment Act (ADEA). Explanation: the ADEA prohibits employers from discriminating against employees aged 40 and older based on age. A. Correct. The employer's policy violates the ADEA by favoring younger employees without valid business necessity. B. Incorrect. The FLSA regulates wages and overtime, not age discrimination. C. Incorrect. OSHA focuses on workplace safety, not discrimination. D. Incorrect. The FLA grants leave for medical or family reasons unrelated to promotion discrimination. Question 15. Topic: Criminal law and search warrants. During a comprehensive examination of law enforcement procedures, a defense attorney finds that police searched a suspect's home without warrant but claimed exigent circumstances due to suspected destruction of evidence. Which of the following would most strongly justify the police's actions? The officers had probable cause and reasonably believed evidence was being destroyed. B. The suspect had prior criminal record. C. The home was located in high crime area. D. The officers found illegal items during the search. Answer A. Officers had probable cause and reasonably believed evidence was being destroyed. Explanation: Under the Fourth Amendment, warrantless searches are generally prohibited, but exigent circumstances allow exceptions. A. Correct. If police reasonably believe that evidence is being destroyed, they can act without a warrant. B. Incorrect. A criminal record alone does not justify a warrantless search. C. Incorrect. Living in a high crime area does not eliminate Fourth Amendment protections. D. Incorrect. Illegally obtained evidence may be excluded under the exclusionary rule. Question 16. Topic: Business law and trade secrets. During a critical business transaction, a company learns that a former employee disclosed confidential client data to a competitor. The employer seeks legal action under the Defend Trade Secrets Act. Say, which of the following must the employer prove to succeed in a trade secret misappropriation claim? A. The information was not publicly available and the company took reasonable steps to protect it. B. The former employee signed a non-compete agreement. C. The competitor is now more profitable than the employer. D. The information was accidentally leaked by another employee. Answer A. The information was not publicly available and the company took reasonable steps to protect it. Explanation: to succeed under the say, the employer must show that the information was 1. Secret, 2. Valuable, and 3. Reasonably protected. A. Correct. Trade secrets must be kept confidential and the company must take protective measures. B. Incorrect. A non-compete agreement does not automatically prove misappropriation. C. Incorrect. A competitor's profitability is irrelevant to trade secret claims. D. Incorrect. Accidental leaks do not constitute intentional misappropriation. Question 17. Topic: Constitutional law and free speech. During a comprehensive constitutional review, a city bans political protests in public parks, citing traffic and safety concerns. Which Supreme Court standard will most likely be used to determine if this ban is constitutional? A. Time, place, and manner test. B. Strict scrutiny. C. Rational basis review. D. Commercial speech doctrine. Answer A. Time, place, and manner test. Explanation: government can regulate speech, but restrictions must be content neutral, narrowly tailored, and allow alternative channels. A. Correct. Time, place, and manner. Restrictions must be reasonable and not overly broad. B. Incorrect. Strict scrutiny applies only to content-based restrictions. C. Incorrect. Rational basis review applies to economic and non-fundamental rights cases. D. Incorrect. The commercial speech doctrine governs advertising, not public protests. Question 18. Topic: Intellectual property and copyright law. During a thorough copyright infringement review, a filmmaker uses short clips from various movies in a documentary without permission. Which legal defense is most applicable under U.S. copyright law? A. Fair use doctrine. B. First sale doctrine. C. Work for hire doctrine. D. Public domain rule. Answer A. Fair use doctrine. Explanation: the fair use doctrine allows limited use of copyrighted material for education, criticism, or commentary. A. Correct. If clips are used transformatively and not excessively, they may qualify as fair use. B. Incorrect. The first sale doctrine applies only to reselling lawfully purchased copies. C. Incorrect. The work for hire doctrine governs employment-based ownership, not fair use. D. Incorrect. Public domain materials do not require permission, but modern films are copyrighted. Question 19. Topic: Antitrust law and market competition. During a comprehensive review of market regulations, the Federal Trade Commission (FTC) investigates a large corporation accused of price fixing with its competitors. The company argues that its pricing strategy is necessary to maintain market stability. Under U.S. antitrust law, which of the following is the most accurate legal assessment of the company's defense? A. Price fixing is illegal per se, regardless of the company's justification. B. The company's argument is valid if it can prove that market stability benefits consumers. C. Price fixing is allowed if the competitors voluntarily agree to set prices at the same level. D. The government must prove that price fixing caused actual harm to customers before taking action. Answer A. Price fixing is illegal per se, regardless of the company's justification. Explanation: under the Sherman Antitrust Act, price fixing is automatically illegal per violation, meaning no justification can make it lawful. A. Correct. Courts do not consider economic benefits when evaluating price fixing cases. B. Incorrect. Even if consumers benefit temporarily, price fixing reduces competition and is still illegal. C. Incorrect. Agreements between competitors to fix prices violate federal law, even if voluntary. D. Incorrect. Price fixing does not require proof of actual harm. It is presumed harmful. Question 20. Topic: Corporate governance and fiduciary duty. During a rigorous board meeting discussion, a company's CEO personally profits from real estate deal that the corporation had an opportunity to pursue. Which fiduciary duty has the EO most likely violated? A. Duty of loyalty. B. Duty of care. C. Duty of good faith. D. Business judgment rule. Answer A. Duty of loyalty. Explanation: corporate officers and directors owe fiduciary duties, including the duty of loyalty, to act in the corporation's best interests. A. Correct. The EO violated the duty of loyalty by engaging in self-dealing instead of acting for the company's benefit. B. Incorrect. The duty of care applies to decision-making quality, not conflicts of interest. C. Incorrect. The duty of good faith involves honesty in ethical behavior, but this case is specifically about self-enrichment. D. Incorrect. The business judgment rule protects directors from liability for poor decisions, not profit at the company's expense. Question 21. Topic: Contract law and unilateral mistakes. During a thorough examination of a business contract, a construction company accidentally underbids a government project due to a clerical error. The company later realizes the mistake and seeks to revoke the contract. Which of the following legal principles is most relevant in determining whether the company can void the contract? A. Unilateral mistake doctrine. B. Consideration doctrine. C. Fraudulent misrepresentation. D. Promissory estoppel. Answer A. Unilateral mistake doctrine. Explanation: a unilateral mistake occurs when one party is mistaken about a material term. The mistaken party can rescind the contract only if the mistake was so obvious that the other party should have noticed it, or the mistake would cause severe hardship to the mistaken party. A. Correct. The unilateral mistake doctrine applies when one party's clerical or calculation error significantly affects the contract. B. Incorrect. Consideration doctrine deals with the exchange of value, not mistakes. C. Incorrect. Fraudulent misrepresentation requires intentional deception, which is not present here. D. Incorrect. Promissory estoppel applies when one party reasonably relies on promise, which is different from mistake. Question 22. Topic: Securities law and insider trading. During a thorough review of financial regulations, an employee buys company stock after overhearing a private conversation about a merger announcement that has not yet been made public. Which federal law most directly prohibits this action? A. The Securities Exchange Act of 1934. B. The Dodd-Frank Act. C. The Sarbanes-Oxley Act. D. The Glass-Steagall Act. Answer A. The Securities Exchange Act of 1934. Explanation: the Securities Exchange Act of 1934 prohibits insider trading, which involves using non-public material information to trade stocks unfairly. A. Correct. Insider trading violates Section 10(b) of the Securities Exchange Act and Sec. Rule 10(5). B. Incorrect. The Dodd-Frank Act focuses on financial regulations, not insider trading. C. Incorrect. The Sarbanes-Oxley Act improves corporate governance and accounting standards, but does not specifically target insider trading. D. Incorrect. The Glass-Steagall Act separates commercial and investment banking unrelated to insider trading. Question 23. Topic: Intellectual property and patent law. During a careful review of intellectual property filings, a pharmaceutical company learns that a competitor has developed a drug with nearly identical molecular properties to its patented formula. Which legal principle will most likely determine if the competitor infringed on the patent? A. The doctrine of equivalence. B. The fair use doctrine. C. The first sale doctrine. D. The public domain rule. Answer A. The doctrine of equivalence. Explanation: the doctrine of equivalence prevents companies from making small modifications to evade patent protection. A. Correct. If the competitor's drug performs substantially the same function in substantially the same way, it infringes on the patent. B. Incorrect. Fair use doctrine applies to copyright law, not patents. C. Incorrect. First sale doctrine allows resale of lawfully purchased goods, not patent modifications. D. Incorrect. Public domain rule applies when patents expire, but this case involves an active patent. Question 24. Topic: Employment law and wrongful termination. During a thorough analysis of workplace policies, an employee is fired after reporting safety violations to the Occupational Safety and Health Administration (OSHA). Under U.S. labor laws, which of the following provides the strongest legal protection for the employee? A. Whistleblower Protection Act. B. Employment-Typical Doctrine. C. Fair Labor Standards Act. D. The WARN Act. Answer A. Whistleblower Protection Act. Explanation: the Whistleblower Protection Act protects employees who report workplace violations from retaliation. A. Correct. Employers cannot fire employees for reporting OSHA violations. B. Incorrect. Employment will allow termination but does not apply to whistleblower cases. C. Incorrect. The Fair Labor Standards Act governs minimum wage and overtime, not whistleblowing. D. Incorrect. The WARN Act requires large employers to give advance notice of mass layoffs unrelated to this case. Question 25. Topic: corporate law and piercing the corporate veil. During a careful legal assessment of corporate liability, a court determines that a company's owners personally used corporate funds for luxury purchases, failed to keep corporate records, and commingled personal and business assets. Under what legal principle can the court hold the owners personally liable for the company's debts? A. Piercing the corporate veil. B. Business judgment rule. C. Doctrine of ultra vires. D. Limited liability protection. Answer A. Piercing the corporate veil. Explanation: the corporate veil separates a corporation's liabilities from its owners. However, if owners misuse the corporate structure, courts may pierce the corporate veil and hold them personally responsible. A. Correct. Courts pierce the corporate veil when owners fail to maintain corporate formalities, use corporate assets for personal gain, or engage in fraud. B. Incorrect. The business judgment rule protects directors from liability for bad decisions, not personal misuse of funds. C. Incorrect. The doctrine of ultra vires refers to actions beyond corporate authority, not misuse of funds. D. Incorrect. Limited liability protection not shields owners, but does not apply when fraud or commingling occurs. Question 26. Topic: securities fraud and misrepresentation in IPOs. During a thorough analysis of financial disclosures, an investor learns that a company misstated its revenue projections in its initial public offering IPO filings. The investor sues for securities fraud. Which federal law most directly governs this type of claim? A. The Securities Act of 1933. B. The Clayton Antitrust Act. C. The Fair Credit Reporting Act. D. The Lanham Act. Answer A. The Securities Act of 1933. Explanation: the Securities Act of 1933 regulates IPOs and requires companies to provide accurate, non-misleading financial information. A. Correct. If a company misstates material facts in its IPO filings, it can be sued under Section 11 of the Securities Act of 1933. B. Incorrect. The Clayton Act relates to antitrust law, not securities fraud. C. Incorrect. The Fair Credit Reporting Act governs consumer credit reports, not IPO disclosures. D. Incorrect. The Lanham Act covers trademark law, not financial misrepresentation. Question 27. Topic: employment law and hostile work environment. During a detailed investigation of workplace policies, an employee reports repeated offensive comments and unwanted physical contact by a supervisor. The company does not take corrective action. Under U.S. employment law, which legal principle best supports the employee's harassment claim? A. Hostile work environment. B. Employment at will doctrine. C. Constructive discharge. D. Bona fide occupational qualification. Answer A. Hostile work environment. Explanation: a hostile work environment occurs when severe or pervasive harassment interferes with an employee's ability to work. A. Correct. The employer failed to prevent hostile work environment which violates Title Roman of the Civil Rights Act of 1964. B. Incorrect. Employment at will allows termination for any reason but does not justify harassment. C. Incorrect. Constructive discharge occurs when an employee quits due to intolerable conditions, but this claim involves ongoing harassment. D. Incorrect. Bona fide occupational qualification B. applies to hiring policies, not workplace harassment. Question 28. Topic: intellectual property and trade secrets. During a thorough legal analysis of intellectual property rights, a former employee discloses confidential client data from their previous employer to a competitor. Which law provides the strongest protection against this unauthorized disclosure? A. The Defend Trade Secrets Act. B. The Lanham Act. C. The Copyright Act. D. The Sherman Antitrust Act. Answer A. The Defend Trade Secrets Act. Explanation: the Defend Trade Secrets Act (DTSA) allows companies to sue employees or competitors for misappropriating confidential business information. A. Correct. Trade secrets, such as client lists, formulas, or strategies, are protected under DTSA, and disclosure without consent is illegal. B. Incorrect. The Lanham Act covers trademarks, not trade secrets. C. Incorrect. The Copyright Act protects creative works, not confidential business information. D. Incorrect. The Sherman Antitrust Act deals with anti-competitive behavior, not trade secret theft. Question 29. Topic: Consumer protection and false advertising. During a comprehensive evaluation of consumer rights, a company falsely claims that its vitamin supplements cure cancer without scientific evidence. Which federal law provides the strongest enforcement mechanism against this false advertising? A. The Federal Trade Commission Act. B. The Magnuson-Moss Warranty Act. C. The Digital Millennium Copyright Act. D. The False Claims Act. Answer A. The Federal Trade Commission Act. Explanation: the Federal Trade Commission Act (FDA) prohibits deceptive advertising and allows the FTC to penalize companies that make false claims. A. Correct. The FTC applies because the company falsely advertised a health benefit without scientific backing. B. Incorrect. The Magnuson-Moss Warranty Act regulates consumer warranties, not advertising claims. C. Incorrect. The DSEA protects digital copyrights, not deceptive advertising. D. Incorrect. The False Claims Act targets fraud against the government, not consumer deception. Question 30. Topic: Mergers and antitrust violations. During a detailed antitrust review, two of the largest technology firms propose a merger that would eliminate most competition in the industry. Under which law can the government block the merger? A. The Clayton Act. B. The Securities Exchange Act of 1934. C. The Robinson-Patman Act. D. The Federal Arbitration Act. Answer A. The Clayton Act. Explanation: the Clayton Act prohibits mergers that substantially lessen competition or create monopolies. A. Correct. Section 7 of the Clayton Act allows the government to prevent anti-competitive mergers. B. Incorrect. The Securities Exchange Act of 1934 regulates financial markets, not mergers. C. Incorrect. The Robinson-Patman Act deals with price discrimination, not corporate mergers. D. Incorrect. The Federal Arbitration Act enforces arbitration agreements unrelated to antitrust laws.